Akube Doromo telling the public about Judge Sullivan and the government corruption, robberies, bank robberies of small businesses and shutting them down. The background of government obstruction, perjury, and conspiracy. Title 18 United States Code Section 241. The government code and the defense counsel Rita Pendry unlawfully, willfully, and knowingly did corruptly influence, obstruct, and impede, and corruptly endeavor to influence, obstruct, and impede due and proper exercise of power of inquiry by certain specific acts, particularly altering, defacing, and obstructing, withholding the evidence from jury and from court records in reference to Title 18 United States Code Section 241, 1505, 1518, and See United States versus Fraser. See Basic Form, Docket Entry Number 36 and 37, date March 30, 2007. See Transcripts March 29, 2007, Docket Entry Number 70, entry date November 30, 2007. Page 70, 107, 108, 131, 132, 141, 145. Also see transcript March 26, 2007 in opening statement, docket entry docket entry number November 30, 2007, page 127 and 149. The code. You may consider only the evidence which is properly admitted in the case. The evidence undoubtedly will include the sworn testimony of witnesses. It will also include stipulations or other matters about which the court takes judicial notice. If it includes those matters, I will define what those matters mean for you at the appropriate time or appropriate term neither during the trial. See March 26, 2007 trial transcript, page 137, docket entry number 67, entry date November 30, 2007. The government and the judge in this case have the entire substantial evidence about the above mentioned, but they mislead the Petit Jury because it was a robbery. The defense counsel Rita Pendry failed to object because she was given something. The government and the court unlawfully, willfully, and knowingly did corrupt, influence, obstruct, impede, and corruptly influence, altering, defacing, and did conspire to omit the indictment from Petit Jury instructions and the jury verdict. See U.S. versus Pressy, and see the court's instruction on March 26, 2007, trial transcripts, page 138, docket entry number 2067, date November 30, 2007, as follows. The court denying defendants from defending himself. The court. The law does not require a defendant to prove his innocence or to produce any evidence. If you find that the government has proved beyond a reasonable doubt every element of an offense with which the defendant is charged, it is your duty to find him guilty of that offense. On the other hand, if you find that the government has failed to prove beyond a reasonable doubt any element of an offense with which the defendant is charged, you must find the defendant not guilty of that offense. See trial closing instructions, March 29, 2007, page 107, 108, docket entry number 70, and entry date November 30, 2007, as follows. The code. And right now I am going to instruct you that, and I just misplaced some of this paper, that there are certain counts in the indictment that you need not to consider, and you need not to speculate as to any reason why you shouldn't consider them, And quite frankly, I have misplaced what I just wrote down. Actually, they are counts 2, 3, 4, and 5, and 17, and 18. The reason why I mention that is because you will see numerically gaps on the basic form. You want to see those numbers. That is because you don't need to focus on those counts in the indictment. And just for clarity's sake, when we send the indictment back, you want to even see reference to those numerical counts just so that there is no confusion. Again, there are counts 2, 3, 4, and 5, and counts 17 and 18 that you need not give further consideration to. See Trial Closing Instructions, March 29, 2007, page 107, 108, Docket Entry Number 70, entry date November 30, 2007. More recently, in United States versus Miller, Supra, the Supreme Court distinguished between an indictment alleging an offense different or broader from that establish a trial, and an indictment means of committing the offense different from those established at trial. The former it held constitute an impermissible variance. Miller was charged with defraud his insurer both by consenting to a burglary and by lying to the insurer about the value of his loss. While on the latter allegation was proved at trial, the court held it insufficient to sustain a conviction. In other words, to successfully resist offense proved at trial and fully alleged in indictment, see Miller Supra, with regard to amendment which infringed on a constitutional right to grand jury indictment, the Supreme Court has adopted per se several rules. The question that Mr. Doromo and the public will ask is, what was that something that given to judge and the defense counsel to allow a fatal, defective, and empty indictment to be presented before jury? The government false misleads the jury. Well, first you will see the checks going into the defendant's accounts for the most part accepted for when on occasion he has decided to buy something for himself, such as Land Rover, a 40,000 car he paid 35,000 cash for. And at the end of the day, after law enforcement officers seized that money, there was still 1.2 million sitting in the defendant's accounts. See Trial Transcripts March 26, 2007, Docket Entry Number 67, page 149. See, okay, I will stop this one here, and what I am asking from the public, I want a support. I want to see that there is a law to all the American people, especially in DC court and the DC Circuit Court. They are all corrupt. Plus, of course, they encourage the Department of the Justice to go outside there to rob, and it is they who will defend it, especially Judge Imaji Salban and the Chief Judge of the Federal Court of District of Columbia Circuit, Chief Judge Santel. He is also accepting corruption to just at least send people in prison illegally without them being found guilty or commit crime, or they are the victims. Thank you.